If we are responsible, the future will be good for the future generations. Bharatiya Nagarik Suraksha Sanhita, BNSS, 2023. Chapter 38, Limitation for Taking Cognizance of Certain Offences, Sections 524 to 526. Chapter 38 of the Bharatiya Nagarik Suraksha Sanhita, BNSS, 2023, outlines the rules and time frames within which legal actions can be initiated for specific offences. Sections 524 to 526 establish the periods of limitation for taking cognizance of certain offences, ensuring that cases are prosecuted within a reasonable time frame to uphold the principles of justice and fairness. Section 524, Limitation Periods for taking cognizance of offences. Section 524 defines the limitation periods for initiating legal proceedings for various categories of offences. The primary purpose of this section is to ensure that prosecutions are brought within a reasonable period after the commission of an offence, thereby ensuring timely justice. Key points. Categorization of offences. Offences are categorized based on their severity and nature, each with specific limitation periods. General limitation periods. Typically, less serious offences have shorter limitation periods, while more serious offences may have longer periods or no limitation at all. Rationale. Limitation periods help prevent the prosecution of stale claims, where evidence may have deteriorated and witnesses' memories may have faded. This section aims to balance the need for timely prosecution with the rights of the accused to a fair trial where evidence remains fresh and reliable. Section 525, Computation of Limitation Period. Section 525 provides guidelines for calculating the limitation periods specified in Section 524. This section ensures clarity and consistency in determining the start and end dates of the limitation period. Key points. Starting point. The limitation period generally begins from the date of the commission of the offence or the date on which the offence was first known to have been committed. Exclusions. Certain periods may be excluded from the computation of the limitation period, such as the time taken to obtain necessary sanctions or permissions to prosecute. Interruptions and extensions. Specific conditions under which the limitation period can be interrupted or extended, such as the accused being absconding or out of the jurisdiction. This section provides a clear and consistent method for computing the limitation period, ensuring that prosecutions are initiated within the legal time frame. Section 526, Consequences of Expiry of Limitation Period. Section 526 outlines the legal consequences when the limitation period for taking cognizance of an offence has expired. This section ensures that there are clear repercussions for failing to initiate proceedings within the stipulated time frame. Key points. Bar to prosecution. Once the limitation period has expired, the court is generally barred from taking cognizance of the offence, meaning the prosecution cannot proceed. Exceptions. Specific exceptions may apply, allowing for the initiation of proceedings even after the limitation period has expired, such as in cases involving fraud or concealment of the offence. Judicial discretion. In certain circumstances, the court may have the discretion to extend the limitation period, considering factors such as the seriousness of the offence and reasons for the delay. This section ensures that prosecutions are timely and that the legal system respects the established time frames for taking cognizance of offences. Detailed breakdown. Limitation periods for different offences. Section 524. The limitation periods vary depending on the nature and severity of the offence. For instance, minor offences like petty theft might have a limitation period of 1 year, while serious crimes like murder or rape may have no limitation period at all. Key points. Minor offences. Shorter limitation periods to ensure swift justice. Serious offences. Longer or no limitation periods due to the gravity of the crime. This section ensures that minor offences are addressed quickly, while serious crimes remain prosecutable irrespective of the time elapsed. Computation and exclusions. Section 525. The computation of the limitation period involves considering the date of the offense and any permissible exclusions. For example, if obtaining a sanction from a government authority took 6 months, this period might be excluded from the limitation calculation. Key points. Clear start date ensures everyone knows when the limitation period begins. Exclusions fairly adjusts the limitation period for unavoidable delays. This section ensures that the limitation period is calculated fairly and consistently. Legal consequences and judicial discretion. Section 526. When the limitation period expires, the court generally cannot proceed with the prosecution. However, exceptions and judicial discretion allow for flexibility in extraordinary cases. Key points. Bar to prosecution ensures legal certainty and finality. Exceptions and discretion provides flexibility for unique circumstances. This section balances the need for timely prosecutions with the necessity of addressing exceptional cases where delays were unavoidable or justified. Summary. Chapter 38 of the BNSS 2023 establishes a clear framework for the limitation periods within which criminal prosecutions must be initiated. Sections 524 to 526 ensure that cases are brought to court within reasonable timeframes, balancing the interests of justice and the rights of the accused. By defining specific limitation periods, providing guidelines for their computation, and outlining the consequences of expiry, this chapter promotes timely and fair prosecutions. It ensures that evidence remains reliable and that justice is administered efficiently, while also allowing for flexibility in exceptional cases to ensure that serious offenses can still be prosecuted. Stay informed. Live in comfort.